Hi there. My name is Tara Reck and I help injured workers in Washington State. I've been representing work injury claimants in L&I and self-insured employer claims for almost 20 years. I posted this video to try and help you identify red flags in your claim when it's about to close. If there are any red flags, you should call a workers' compensation attorney for free consultation. If you're managing your own claim, this video can help a lot. You can also use the video to check if L&I is not managing your claim properly. Finally, please subscribe to my YouTube channel and check my other videos. Closing an L&I claim can be very stressful. It's the number one reason people call my office, because their claim is about to close. So first, let's talk about Maximum Medical Improvement or MMI. Your claim cannot close before you reach maximum medical improvement. You achieve it when there's nothing more that doctors can do for you. Unfortunately, it doesn't mean you're healed. It just means that doctors don't think you'll get better with more treatment. However, that's just their opinion. Very often, it's unclear if you're actually at maximum medical improvement. An IME can say you're MMI, but your attending provider might think you need more treatment. If that's the case and your claim is closing, then that's a red flag. Again, if you have any red flags, you have to call an attorney. Second, let's talk about future employment issues. L&I must handle future employment concerns before a claim can close. For example, if you have total disability. That's just one example where L&I can't just close the claim. At the very least, they have to pay for your disability. Total disability doesn't mean that you're helpless. It means you have physical or mental impairment. And that it impacts your ability to find or maintain a job. L&I must evaluate and decide if you're employable. For that, they look at your age, education, skills, training, experience, and limitations. One way for L&I to resolve total disability is with L&I pension. If you think you have total disability and you're not getting a pension, it's a red flag. L&I pension is a complicated topic, please check my other video about pensions. Next, there's permanent partial disability or PPD. Some work injuries or occupational diseases cause permanent conditions. For example, a loss of body function can be permanent. L&I has methods to assess your level of PPD conditions. A medical expert or IME can perform a PPD rating. Sometimes, your attending provider can do it. After the rating, L&I decides the amount of your PPD award. One red flag is when you have permanent limitations without PPD rating. Another red flag is when your PPD rating is too low considering your symptoms. A third red flag is when you don't receive a PPD award. And another is when some doctors disagree with your PPD rating. All these red flags are very important, and you should watch out for them. Now let's continue. The next area for red flags is when there are unresolved problems in your L&I claim. Some L&I claims start to close when there are still some ongoing issues. That's a big red flag. For example, closing a claim while there are time loss compensation payment problems. Another example is closing a claim with outstanding medical bills. You should know your claim and follow all the details. If there are any ongoing issues, you must resolve them before closing the claim. There are plenty of claims and cases with no red flags. Very often, claim closure is appropriate. However, improper claim closure is also common. When your L&I claim closes, L&I sends you a letter. If your claim closed and you didn't receive a letter, you must speak with an attorney. Usually, the closing letter contains a payment order or notice of decision. After that, the decision becomes final in 60 days. This means you have 60 days to protest or appeal. Personally, I always think it's a good idea to talk to an L&I attorney if your claim is closing. You can always receive free information and tips that can help. If you claim closed, you can always file a reopening application. If successful, L&I will keep the claim open and work to resolve remaining issues. However, sometimes your claim closes after they fix all remaining problems. In this case, you can still reopen your LNI claim in the future under certain circumstances. For example, if there's an aggravation and your condition gets worse. If it does, you must get objective medical opinions and tests to support them. You can also reopen the claim if your aggravation justifies a higher PPD rating. LNI can even reopen a claim when a doctor finds new conditions. The conditions must relate to the workplace injury or work illness. That's true even if the condition wasn't known before claim closure. Finally, there's the 7-year reopening rule. If you reopen the claim within 7 years after it closed, all claim benefits may be available. This includes medical treatment, time loss compensation, and loss of earning power. It also includes PPD and even pension benefits. But, if you reopen a claim after 7 years, you can only get more treatment. That's unless the director of LNI grants you other benefits at their discretion. LNI claims are complicated. If you feel there are any red flags in your claim, please don't hesitate to pick up the phone and give our office a call for free consultation.